Moving on, we'll try to understand fundamental rights as enshrined in the Constitution of India. As we know, fundamental rights are rights that are core to the principles of any state, and they describe what does the state really aspire and stand for in terms of protecting the rights of citizens. As I told you earlier, these are essential rights. They are inalienable rights. They are rights that cannot be infringed, compromised. At the very rarest of rare extent, it can be done so, but it can be done only through the procedure established by law and nothing more than that. Now, fundamental rights under Part 3 of the Constitution of India can be, in an outlook of an overview, you can look at, say, Article 14 till Article 32. All these are fundamental rights, and the right to equality stands from Article 14 till almost Article 18, which talks about abolition of titles. So this is the chapter that deals with right to equality. Then you have Article 19 that talks about freedoms. Then you have Article 20 uh, and 22 that talk about the rights of detainees or those who are convicted of offences. Of course, you have Article 21 that talks about right to life and personal liberty. And one of the new additions to the fundamental rights chapter is the right to education, Article 21A. Article 23 talks about trafficking of human beings and forced labor. There is a clear constitutional prohibition about it. These are all mostly prohibited kind of activities. So they protect your rights in a negative context. So, rights can have positive connotation. They can also have a negative connotation. So we will discuss about this as we go forward. You have the freedom of, consciousness, uh, in terms of exercising your religion, profession, and practice, uh, and you also have the freedom to manage religious affairs. Um, Article 25 onwards, you will notice, is about the freedom of religion and management of religious institutions or educational institutions by religious entities. So, if you see Article 29, you will also see the protection of interest of minorities. 29 and 30 actually give minorities even the right to manage their educational institutions. What class of minorities are we speaking about? Are they religious? Of course, they are. And you also see that religious institutions have a certain degree of autonomy and freedom and protection of rights under the constitution as well, and hence the very aspect of the secular character of India gets promoted by some of these articles. And of course, the fundamental rights chapter gets closed by Article 32, which is about the constitutional remedies, as the case may be. So, having looked at the brief outline of these fundamental rights, I think we should move on and deal with what is the right to equality under Article 14 of the Constitution of India. Now, friends, the right to equality, as enshrined in the Constitution, covers four articles. These are huge and bulky articles that speak a lot about what is the rule of equality under the Constitution of India. And you will notice that uh, this whole process, the origin, while we say equality before law and equal protection of the law. Now, equality before law is actually taken from the British, concept, while as equal protection of the law comes from the American Constitution. Now, when you talk about equality before law, what does it mean? I think let us understand this in the primary context. It means when I say you are uh, equal before the law, it means the following things. First, it means that there is an absence of any special privilege in favor of any person. Uh, Please note again, while we talk about special privileges to special persons, This is a rule that there is a general assumption that there is no absence, there is absence of privilege. So privilege cannot be granted to individuals. I think everyone has the right to be treated equally before the law. Now, please note this is the rule. Of course, we will talk about the exceptions that are provided in the Constitution itself in terms of certain constitutional authorities who have been granted certain privileges under the Constitution. So, while the rule says everyone will be treated equally, it clearly means that there is absence of any special privilege in favor of any person. That's the first point. Second, all individuals shall be subjected to the ordinary law of the land. For certain people, you cannot make certain laws, give them, certain kind of entitlements. This is the normal rule that, all persons shall be subject to the ordinary law of the land, and every person is below the law, law is above him. This is what equal protection of the law would mean. But again, this is the rule, this is an assumption. However, if you look at the Constitution itself, there are certain exceptions that can be made in terms of scheduled areas, and these are places where probably people living over there need certain kind of protection, and hence, while everyone is subject to the general law of the land, there may be a special law for that kind of special areas, and this may exclude people. For example, Indians may be excluded from buying land in a scheduled area which is notified and designated as such. So while we say that everyone is subject to the ordinary law of the land, of course, in special circumstances there could be special privileges that can be granted. But this is a rule, and the exceptions have to be followed as well. The third connotation of equality before law also means that however rich you are, however high you are in the economic strata, or however high you are in holding an official power, I think you will notice that everyone is supposed to be below the law and law is above it. So, whether you're rich or whether you're powerful, you will be subject to the same treatment before the law, and everyone has the right to be treated fairly before the law. This is what do you mean by equality before the law. Now, if you talk about equal protection of the law, this concept can have the following entitlements. What could it be? First, the equality of treatment under equal circumstances. When you say equal protection, which means uh, when you talk about certain treatment that I should be entitled to, I think two people should be treated equally in terms of protection. So I may be an accused of a particular kind of a crime, and there would be someone else who may be a privileged kind of a criminal. I think both have the duty to claim equal protection of the law in the prison. The state ought to take care of them, right? So while we talk about, say, VIP prison and so on and so forth, I think these are concepts where equal protection of the law definitely gets infringed even for an accused. So equal treatment of equal persons, right? Now, when we talk of equal persons, of course, women and children are not necessarily to be treated equally. They may have different circumstances as well. Uh, equal uh, equal protection of the law also means that when the government in public administration receives application, you know, every applicant is treated equally, and there is no aspect of favoritism. There is no aspect of nepotism. Every man or woman in the nation has the privilege to be treated equally before the public administration. So, similar applications should be treated similarly. Dissimilar application can be treated dissimilarly. That's the normal rule. So, we always say there is a very interesting rule in equal protection of the law, and that is the likes should be treated alike without any kind of a discrimination, right? Alike should be treated alike without any kind of a discrimination. So, you will notice that the equality rule is a positive assertion of a right. It expects law to give you a right in terms of what you can actually positively utilize. So, very clearly, friends, equals cannot be treated unequally. Uh, However, the likes should be treated alike. These are certain, phrases that actually describe the equal protection of the law principle. Now, let's just, to understand basically what is written in Article 14, it says that the state shall not deny any person, the state shall not deny any person equality before the law or the equal protection of law within the territories of India. And interestingly, please note, it says state shall not deny any person equality before the law and equal protection of the law, which clearly also tells you that Article 14, the rule of equality, protection, and kind of treatment before the law. This is available to both citizens as well as non-citizens. So Article 14 is not exclusively for citizens. So this is something that you have to understand. This is point number one. Point number two is Article 14, the rule of equality applies to all kinds of persons, be it natural persons or be it legal person or a juristic corporation like a company, like a partnership, like a cooperative, like a society, like a university. It could be a company which is private in nature, or it could be a one-man company. It could be anything. So everyone, as long as you are a person in the eyes of law, you can demand equality, because companies actually make application to the government sometimes for licenses and privileges in terms of extraction of coal and other natural resources. Like has to be treated alike. And very importantly, please note, equals have to be treated equally. As soon as you are treated unequally, then you feel that your rights are going to be infringed. There is discrimination by the government, and hence, such kind of actions, whether administrative or otherwise, can be challenged in the court of law as being violative of Article 14. So, wherever government discretion is abused, there is an allegation of unequal treatment. Please note, usually it is challenged in the court of law, and that is how judicial review of governmental actions, especially on the grounds of discrimination, are generally challenged as violation of Article 14. So Article 14 that way is a control on government power and government regulation, and it expects government to be fair in treatment of all citizens, and the rule is in terms of treating them equally as well. Of course, why should equality be important, or what is the need for us to discuss the rule of equality under Article 14? Or why should the government look at non-arbitrariness in its public administration? Friends, please note, when all members of the population are treated fairly, all members of the population are treated fairly and without any kind of a bias, that is only when democracies can prosper. Right? Democracies cannot have privileges granted to a certain sections of the community. That section of the community may be a majority community or a minority community. It could be a religious denomination, or it could be a privileged, powerful denomination. I don't think that is the process, and hence, a democratic constitution expects every member of the population, be it how high, low, economic, social, or other kind of considerations, should not apply, and everyone has the right to be treated equally, fairly, and without any kind of a bias from public administration. That is where the rule of equality plays a very, very important, and I think it's one of the basic features of the Indian Constitution. It is so important in terms of, say, upliftment of different sections of the community, be it those who are economically weaker or socially who are backward. So, in terms of expectation of growth, in terms of expectation of government schemes and policies, you will notice that equal treatment and providing equal opportunity of treatment becomes so very critical in the developmental agenda of the state. I think every state must be the guardian of the rule of equality. And I think when let's take the instance of the farmers being treated unequally by the state, what will happen? It will result in an agrarian crisis. It will result in a shortage of food supply. It can result in farmer suicide, and so on and so forth. So I think the kind of challenges that equality can pose if it's not adhered to are quite a bit. Okay, now interestingly, friends, we have to speak about equality in terms of the following sections. Now, please note, Article 15 also brings in the rule of equality, and it says the discriminations if any, right, cannot be done on the ground of religion. So, religion cannot be used to discriminate. Religion cannot be a ground to have unequal treatment. Second, race. Of course, India has so many races, right? From northeast to southern India, I think we come from different races. Can there be discrimination on the ground of race? Can there be discrimination on the ground of caste? India is so divided on the basis of caste. Can there be discrimination on the ground of sex? Women treated differently than men. We have an interesting connotation of a principle called equal pay for equal work. So, men cannot be paid more just because they are men if women are contributing to the same, type and quantum of work. There cannot be discrimination on the place of birth as well. This the state should not follow, and this is clearly established under Article 15. However, please note, of course, place of birth and other issues can only be accessed by Indian citizens, and reasonable restrictions can be imposed on some of these, bases. As I told you, certain areas in India, in the territory of India, we may have to impose certain restrictions for the protection of local communities and for other security and strategic interests, as the case may be. So, uh, Article 15, Article 16 are very, very critical. Coming to Article 16, friends, you will notice that Article 16 guarantees equal opportunity for all citizens in the matter of employment and in the appointment of any office under the state. So, no citizen shall be discriminated in public employment on the ground of religion, race, caste, sex, descent, and place of birth or residence. However, can the state provide for reservation of appointments or certain kinds of post can be reserved in favor of the backward class that is not adequately represented in the state service? The answer probably is yes. There is something called the reservation policy, and the state is permitted to make a certain percentage of reservation for posts that may favor economically weaker sections of the community. So, generally, up to 10% reservation in certain appointments and posts for economically weaker section of the community is permitted. Uh, Please note this is the reservation on economic consideration, not on social consideration, right? So, today, whether reservation is based on a social parameter or economic parameter, the answer could be that it could be on both, right? So, interestingly, the economic reservation angle is a very recent introduction, and it was done through the 103 constitutional amendment that was made in the year 2019. And this is specially called the EWS category in public service of the government of India. So, up to 10% now is given based on your income. It's based on your economic dimension, not on your social dimension, which was the traditional original reservation rule in terms of backwardness. The backwardness here was on social and caste dimension. Today, this 10% reservation that was brought about by the 103 amendment is on the economic backwardness, not on the social backwardness. So, this has now been provided under Article 16 of the Constitution. Yeah, there are a lot of interesting cases on Article 14. I think the Keshananda Bharati versus State of Kerala case is the landmark case, which talked about the doctrine of basic structure. Of course, today we do celebrate 50 years of this doctrine. We celebrated that in 2023 because I think because of this doctrine in 1973, there was a limitation that was imposed on the power of the parliament to amend the constitution. See, the constitution should be a dynamic document. It cannot be a completely static document. But however, it cannot be so dynamic that it gives one party in the parliament that has majority to change the basic dimension or structure of the constitution. The constitution should have consistency and uniformity or predictability and should have certain basic values that no government, irrespective of whichever ideology or party or thinking that they come from, should have the ability to change the same. Is the rule on equality a basic structure of the constitution? I think to some extent the answer was in an affirmative. Right, the principles of equality. I would not say in the same way in what is written in 14 and 15 or 16. I think, see, for example, can reservation criteria change? It can change. Can reservation from social, can it come to economic? From economic, it can go. I think those are, from 10%, can it increase to 30%? These can change. There is some, flexibility that can be brought about. But the core principle of equality, which is there in Article 14 of equal treatment and equal protection, I think that has been agreed as the basic principle and the basic structure of the Constitution. So, privileges and immunities should be rare, and they should be something that cannot be granted to all from time to time. So, I think protection on the ground of equality is a basic rule of the public administration. So, public administration has to treat equals equally, likes alike. This is the basic foundational rule, and it's part of the basic structure of the Constitution. There cannot be any compromise. And I think how fairly you treat or apply this equality principle is how fairly you can judge good governance. It's as simple as that.